We are honored to welcome you to this program, created to bring our National Advisory Committee members expertise into conversation with the public. It is fitting that our keynote speaker is Leila Sadat, whose work so powerfully reflects the values and vision that Norman Cousin championed throughout his life. Leila is the James Carr Professor of International Criminal Law at Washington University School of Law and the former director of the Whitney R. Harris World Law Institute. She is an internationally recognized expert on the International Criminal Court and served as special advisor on crimes against humanity from 2013 to 2023. She is also the director of the Crimes Against Humanity Initiative, and in 2025 received the Goler T. Butcher Medal from the American Society of International Law in honor of her work on international justice. And this is just to name a few of her accolades. So thank you, Leila, for joining us today to speak on the Crimes Against Humanity Treaty. And before the lecture begins, we would like to present Leila with the Norman Cousins Global Governance Award. It is now my pleasure to introduce our moderator for this morning's program, Margot Malambu, who will formally present the award. Margot serves as one of this year's CGS Fellows. Margot?
Thank you. Thank you, Julia. Good morning, everyone. My name is Margot Malumbu, and I am honored to be here today as one of this year's Citizens for Global Solutions Fellow and as the moderator for today's session. Today, CGS is deeply honored to present the Norman Cousins Global Governance Award to Professor Leila Nadya Sadat. This award recognizes individuals whose work expands public understanding of world law, global governance, and the urgent need for international cooperation rooted in justice and human dignity. It is named in honor of Norman Cousins, a journalist, peace advocate, citizen diplomat, and former president of the CGS, who believed that humanity's survival depended upon extending the rule of law beyond national borders. Professor Sadat's work embodies that vision. For decades, she has been one of the world's leading voices in international criminal law and human rights. Through her scholarship, advocacy, and institution building, she has helped shape the global movement for accountability for crimes against humanity, some of the gravest crimes known to humankind. Most notably, Professor Sadat has led the international effort to advance a proposed Crimes Against Humanity treaty, an effort to close one of the most significant gaps in international law. While the world has treaties addressing genocide and torture, there remains no dedicated global treaty focused specifically on preventing and punishing crimes against humanity. Professor Sadat recognized the gap not simply as legal oversight, but as moral failure, and she has worked tirelessly to change it. Her leadership has brought together governments, legal scholars, civil society organizations, and advocates from around the world in pursuit of a stronger international framework to protect civilians from atrocities, including murder, torture, sexual violence, persecution, and forced displacement. But beyond her extraordinary accomplishments, what makes Professor Sadat especially deserving of this recognition is the spirit in which she has pursued this work. With international rigor, moral courage, and unwavering belief that international law can and must serve humanity. At the time when international institutions are often under strain, Professor Sadat reminds us why they matter. She reminds us that accountability matters, that human dignity matters, and that building a more just world requires persistence, imagination, and principled leadership. These are precisely the values that Norman Cousins championed throughout his life, and precisely the values this award was created to honor. Professor Sadat, on behalf of CGS, it is our privilege to recognize your extraordinary contributions to international justice and global governance with the 2026 Norman Cousins Global Governance Award. Please join me in congratulating Professor Leila Sadat.
It's actually a photo of it because I'm in New York City doing, guess what, working on the treaty for a couple of days because the work on the treaty just never stops. I can't tell you, Margot, Andrea, and to everybody at CGS, how incredibly honored and sort of humbled I am to receive this. When I hear the description, I don't even recognize myself, but it is true that for whatever reason, for me, this campaign to get this new treaty represents a huge investment in humanity's future. It's an effort really to restate that human dignity matters, that nonviolence matters, that the norms that shape the creation of the United Nations at the end of World War II still matter, and that the world needs their reinforcement and needs protection. And we see all around the world the fact that civilians are being targeted. They're being targeted for starvation. They're being targeted with bombs. They're being targeted with sexual violence. And this is something that's afflicting every single region of the world. So I'm really honored because I will say I was trying to count how many lectures I've given on the treaty, PowerPoints, blogs I've posted, articles and books I've written, and it's kind of a lot. And so I will say that receiving an award like this does put a little, wind beneath my wings, because it helps me kind of fly further to the next stop. I'm going to talk today in my lecture about the treaty. It'll be a little legal. I hope that's okay, because it is a legal document. But I do think everything you said, Margot, everything you said, Drea, it's about human values. It's about our commitment to a better world. And it's everything that CGS stands for. And I'm so proud to receive this and so honored and so proud to be part of CGS. So thank you so much. Thank you, really.
Thank you so much, Professor Sadat. It is really a privilege to have you with us today. But at this point of time, I would like to turn the floor over to you.
So, I'm going to offer some reflections. I'm looking at my clock. I don't think it'll be too long, and I'm going to offer some reflections on the new the effort to create a new treaty on crimes against humanity, sort of where we've come from, where we are now, where we're going today. We have a long campaign in front of us, but it's an exciting moment. It's just also a strong moment. So in 2008, I created something called the Crimes Against Humanity Initiative. And the reason I created it, and you can see some of the mothers and fathers of international criminal law in this picture. We brought them all to St. Louis, Missouri, um, for a conference. And you can see Sharif Bassiouni, who was, of course, the father of the International Criminal Court, Richard Goldstone, Bill Shabis, Hans Karel, Judge Christine Van den Weingart, lots of good friends and colleagues. And I brought them all to St. Louis because in 1994, I had read this little article by Professor Sharif Bassiouni that said, the world is shockingly complacent that we don't have a dedicated global convention on crimes against humanity. And I had sort of filed that back in my memory. And it was one of, I was a young, very, very junior scholar, and I read everything that was out there. And I thought, that is a bit odd. That's what the Nazis were prosecuted for at Nuremberg. They weren't prosecuted for genocide. They were prosecuted for crimes against humanity. And why did that matter? Well, fast forward to 2007, the International Court of Justice heard a case brought by Bosnia and Herzegovina against Serbia and Montenegro, alleging that genocide had been committed in the former Yugoslavia against the Bosnians and asking for relief. And the International Court of Justice had jurisdiction because the Genocide Convention has what we call a compromissory clause, that is a provision in the treaty that allowed it to take jurisdiction. And so the only thing the court could discuss was whether or not genocide had been committed. And it had found that outside the massacre of Srebrenica, in fact, genocide had not been committed in the former Yugoslavia and not been committed in particular by Serbia, although Serbia had failed to prevent the massacre at Srebrenica. And it did, there's a little sliver of hope in the case. So all of us read that because when the court issued a press release about it, it said, look, we see that 100,000 people were killed, that there was a mass rape campaign, that there was torture in detention centers. But all of these are other crimes, in particular, crimes against humanity and war crimes. And we don't have any jurisdiction over those. We only have jurisdiction over genocide. And I thought, well, that's ridiculous because genocide is so impossibly difficult to prove, and it only covers four groups. It doesn't cover politicide and social groups and discrimination on gender basis. And so that's when I said, let's resurrect this idea of doing a new treaty. We get the International Criminal Court Statute in 1998, and the Rome Statute defined crimes against humanity for the first time in a multilateral treaty. So the Rome Statute defined crimes against humanity, but gaps remained. It didn't have an enforceable duty to prevent. It didn't provide for state responsibility, so no case like Bosnia versus Serbia was possible. We didn't have interstate enforcement or mutual legal assistance. Legal entities weren't justiciable, right? Companies, corporations. It wasn't binding. The ICC statute is fantastic. It's an amazing achievement. There are 125 states parties to the Rome Statute system. But there are a lot of countries that are outside the system. It's built on a vertical system of enforcement as opposed to horizontal. And the ICC, as we now know, we predicted this in 2007 and 2008, but now we know for a fact it's going to take very few cases. So we wrote a treaty. The first time that anybody had ever actually drafted a treaty. It had 27 articles. It had annexes on interstate cooperation. It took the Rome Statute definition for its centerpiece. And remember, crimes against humanity are attacks against a civilian population pursuant to a state or organizational policy that are widespread or systematic. That's the definition. And then there are 11 crimes that are listed as the actus reus, as the criminal offenses. And so we built this pillar of this convention on the normative importance of preventing crimes against humanity, of punishing crimes against humanity, capacity building for states, and all sorts of other things were in the treaty. Why is it so important to criminalize crimes against humanity? Well, there's something that I've called the atrocity cascade, which is that crimes against humanity sort of they can be committed in peacetime or wartime. So in that way, they're much larger than genocide because than war crimes, because war crimes are limited to armed conflict. And they're much broader than genocide because genocide, you have to show an intent to destroy one of these four specific groups. And what I really found during my 10 years of work at the International Criminal Court is that, in fact, what the biggest issue we faced was when do human rights violations get so systemic or so widespread within a state that they become crimes against humanity. And so you can see from my slide that if you care about genocide convention, if you care about preventing war, you really have to criminalize crimes against humanity because they can occur prior to the onset of armed conflict. It's very unusual to have a genocide without an armed conflict. It's technically possible. But where you really see it is, for example, in Bosnia, you saw war crimes, you saw crimes against humanity, and under the jurisprudence of the Yugoslavia Tribunal, there were pockets of genocide taking place in places like Srebrenica. So the project moved from us to the International Law Commission, and I could try to explain how that happened, but we're just going to say divine intervention at this point because we held a series of conferences for our work. And Professor Sean Murphy came to our conference at the Brookings Institution, and he loved this idea of a new treaty on crimes against humanity. And he then got elected to the UN International Law Commission, which is the body that sits in Geneva every summer. And it is responsible under its charter and Article 13 of the UN Charter for the progressive development and codification of international law under the auspices of the General Assembly. So the ILC actually takes up various topics. It can produce principles or guidelines or draft articles. It actually produced the draft for the Rome Statute of the International Criminal accord that states then took up and negotiated in 1998. And this is a picture of members of the commission coming to a conference that we had hosted at the Villa Moigné in Geneva, to try to encourage the commission to not just take up the topic, but move it to its active program of work, which it did. And so the commission then went through its own process. It issued a first set of draft articles in 2017. It then received comments from governments and civil society, and then issued a second reading in 2019. And the 2019 draft articles are the basis now for the negotiations that have been ongoing. And this is work that was done over a series of years by the commission, and that then the commission, I should say, it reports to the General Assembly every fall. So the commission is always in dialogue with states when it's doing its work. It does its work, it then issues a report, and the report is transmitted to New York, and it's taken up by the legal committee of the General Assembly, known as the Sixth Committee. It took for its definition, the Rome Statute definition, that it changed just a little bit, including deleting the definition of gender. It has 15 articles, standard criminal law treaty with obligations of prevention and punishment, establishment of jurisdiction, provisions on investigation, victims and witnesses, the obligation to try or extradite. That's very important. And importantly, remember my story about Bosnia versus Serbia, a dispute settlement clause that would allow not just individual criminal responsibility, but state responsibility. That is, a state could bring another state to the ICJ alleging that there had been a violation of the treaty. The commission finished its work and said to the General Assembly, hey, guys, didn't say it that way. It's very formal the way it speaks, but hey, General Assembly, you should take this forward and create a new treaty. We've done some great work here. And they had really done some great work. The draft articles are a wonderful product. And what I love, and I kept this slide, and one of my students said to me, Professor, was it really the 3,499th meeting of the ILC? And I'm like, yes, you can read it in the records. Why is that so important? Folks, it took 75 years after Nuremberg, right, to get a draft of this treaty. It's pretty shocking when you think how important crimes against humanity are to atrocity prevention. And then we moved to New York from Geneva. Okay, so those are my reading glasses, and I go to all the meetings. And when it moves to New York, we run into some legal and procedural obstacles. I don't really have time to go into all of them, but as you can imagine, there's some states that are not really too happy. Why had it taken 75 years? Because there's some states that really are pretty concerned about the idea that widespread or systematic attacks on civilian pursuant to a state or governmental policy could become criminal and subject to adjudication and prevention and punishment. So for 6 years, we bandied about in the General Assembly, in the UN Sixth Committee. We had a series of technical rollovers, meaning that it would go into the Sixth Committee. There'd be some debate in the Sixth Committee. States would say, hey, this is a great idea. We should move forward. And then a couple states would be like, we're not ready. We don't think the work was good enough. We're really not very happy. And the problem is that the United Nations Legal Committee operates on this tradition of consensus, which is really giving any naysayer state a veto over a product. And so what happens is for 4 years, basically, we get a series of technical rollovers and no forward movement. And then we had a breakthrough in 2022 because by that time we were past the pandemic. Civil society, people like CGS members could get back into the UN because during the pandemic for 2020 and 2021, we couldn't even enter the building. And then we started to get some resume sessions and discussion under a General Assembly resolution. And what was really exciting about this, and I think this should excite all of you feeling depressed about international law, not only has the advocacy on this treaty been largely female-led, myself and my team and my friends, but Global South led. It was Mexico and the Gambia that actually introduced a resolution to break the stalemate in the Sixth Commate, and they got this resolution 77/249 that required 2 years of debate of the draft articles with a clear mandate and a structured timeline, and required that states take a decision in 2024 in order to decide what to do with the draft. And in 2024, we were very excited because we thought we were going to get a 2-year process and we'd have a treaty this year. Well, that didn't happen, but we did get a good decision. And I was there on November 22nd, 2024. I'll never forget. We did have a lot of states. You can see I've been tracking state participation in the treaty process, in the discussion ever since 2013 when it went to the commission. And you can see there's a dip in 2020, which is just the pandemic dip because a lot of states weren't participating. But you can see steady growth and enthusiasm from states, which allowed a momentum to build to push this over the top. I'm going to go forward and then go back. So we got a resolution in 2024 that basically set out a 5-year process. That's a long time, but we've been waiting 75 years. We can wait 5 more years. We're actually in 2026, so we're doing well. And you can see in 2025, then we really had to encourage our advocacy for the treaty. I think I came to New York 8 times over the last few months. And then in January of this year, there was a preparatory committee meeting for 2 weeks to take a decision on civil society participation, elect a conference bureau, and allow states to make substantive comments about the draft and pave the way for states to also propose amendments to the draft. And those amendments were actually due on April 30th. So we will see this summer a compiled text consisting of the draft articles and the state proposals that came in as sort of the text that will be sent to the diplomatic conference. States can continue to amend. We'll continue our advocacy on issues we care about, but we will be very curious to see. We know already what some of the progressive states are doing because they're sharing, but we haven't seen the naysayers' proposals, which we expect we probably won't like. So let me go back. The 2019 draft articles were really good. But we did see states during the 2 years of resume sessions, and we heard it in the PrepCom, that, there's some issues that the draft articles didn't cover. So that's one bucket of proposals. Civil society is also, and states are also proposing some changes in the Rome Statute definition, mostly additions. The crime of starvation has been proposed. The crime of forced marriage has been proposed. The crime of environmental harm as a crime against humanity has been proposed. Slave trade has been proposed. Either because there's a perception that the Rome Statute is missing something, that the definition of persecution, for example, needs to be expanded, or because international criminal law has simply evolved since 2025. We have new crimes, and that's fairly normal in a treaty codification process. And then we're seeing some states propose changes to the draft articles in order to strengthen them or clarify them. And I'll talk a little bit about what some of those are. So here are a few of them. One of the most important things, I think, is the creation of a treaty monitoring body. So we have monitoring bodies for the human, we have the Human Rights Committee for the International Covenant on Civil and Political Rights. We have the Torture Committee for the Torture Convention, Enforced Disappearances Committee for the Enforced Disappearances Convention. The idea is you want to prevent, so you want to monitor. You want to have an authoritative body that's there to sort of oversee the implementation and assist with capacity building. And so there are many, many proposals that I think we'll see more emphasis on children's rights, more emphasis on gender competency, more emphasis on prevention, tightening up some of the preambular provisions, et cetera. That said, there's some states that will propose negative things, like we've heard a proposal that there should be immunity for the commission of crimes against humanity for state officials. That obviously would be problematic, both with customary international law and the ILC draft. We've heard a proposal that there should be a hierarchy of jurisdictions with the territorial state having primacy, which could be a problem if the territorial state is the state committing the crimes. So we will see what happens as this roadmap. In the sixth committee, we saw lots of participation, even more states actively supporting the treaty. We did see about 11 states. That's been sort of 10 states, 10 to 11 negative states is what we've seen all through this. There are not a lot of states that oppose the process, but they're loud and they're very effective. During the PrepCom, we saw a great deal of state participation. 100 speakers, 94 state speakers, many, many different regional groups. The PrepCom also created a working group, Resolution 79/122 created this strange thing where it had a committee that was the preparatory committee to prepare the diplomatic conference. And inside that was a working group. And we were afraid it would close the working group, and it was technically closed to all NGO representatives that couldn't physically be present in New York. So it wasn't webcast. You had to go to New York to actually listen. And we've done a huge compilation of the work there. And again, listening, we sort of saw three trends. Some states really saying, let's go, let's seize the moment. This is an historic opportunity. We need to create a treaty that's going to be good for the next 100 years. We had our handful of opponents that used mostly procedural objections constantly to slow down the process and kind of throw a monkey wrench into the work. And a small number of WEOG states that support the treaty. WEOG Western European, right? So Germany, some other countries like that. They support the treaty entirely, but they don't want to touch the Rome Statute definition, and they're fairly conservative about touching the draft articles. And so we haven't yet seen the coalescence of a like-minded group of states, which we saw for the Rome diplomatic conference for the ICC statute. But I think that's normal because we're 2 years away from actual treaty negotiations, right? They finally elected a chair that took the entire morning practically because of Russian and Egyptian objections. And then they elected a bureau. So the bureau are like the representatives that are going to preside over the next preparatory committee meeting in April that will adopt the rules of procedure for the diplomatic conference. They had thought the Secretariat and the Sixth Committee had decided on one individual per regional group, which would have been a bureau of 5. The Russian Federation objected, and they actually had to have a vote because the Eastern European group had 3 candidates, Russia, Ukraine, and Slovenia. And you can see that it was the Ukrainian and Slovenian representatives that were elected, but the Russian Federation got 74 votes, which was pretty considerable. So there's definitely going to be obstacles in the future. In CSOs, and you'll have to forgive me, I do have pictures of some of my colleagues and friends, and this was really hard work. We actually produced a report suggesting various textual proposals that could be introduced by states. What was a little discouraging is 117 civil society organizations were accredited. Only 14 delivered statements in New York because so few could get their visas, so few could come to New York. It was very expensive and it was very hard to come. So getting civil society participation in this process, treaties, survivors in particular, groups of victims, that's going to be very difficult. But we did get a very good decision on civil society participation. We did a paper on it. We did a lot of lobbying around it. And the good news is there will be a process for even representatives of non-governmental organizations that do not have ECOSOC status to get accredited to the diplomatic conference. And that was hard fought. And then it was gavelled in a second on the last day of the PrepCom. So that was very exciting. I wish I should put I have a little video clip of the applause because we worked very, very hard on that. Here's just some of my student team because just young people are driving this movement, and the needs of survivors and victims are driving this movement. The Global South is driving this movement. Sierra Leone, Gambia, Mexico, Costa Rica, small states have really been at the forefront. And I just want to say, this treaty isn't about legal rules. I mean, it is about legal rules, but it's about people. It's about reinforcing the values of humanity in a new instrument that clearly says, in an era of artificial intelligence and war and conflict and threats to international institutions, that human dignity and the right to be free from the commission of atrocity crimes come first. And I put this little slide that I found. This is an old picture during the transatlantic slave trade, which was really where the term crimes against humanity originates originally, as a description of the transatlantic slave trade. And to stop the trade, the British entered into treaties with other countries and established a series of treaty courts that and these treaties allowed the British, mostly it was the British Navy, to actually interdict slave trading vessels, board them, take them to shore, take them to court, and free their captives. And through that process, particularly the slave courts in Sierra Leone, this is now during the 19th century, freed about 150,000 people. And now, compared to the 13 million who were trafficked, you could say that's a drop in the bucket. But every one of the human beings that was taken off one of those vessels or didn't go onto a vessel because the vessel was even impounded before it could take its cargo, that was a human soul that was saved. And so that's why we need legal rules. That's why we need treaties. That's where our commitment comes. It's not just going to be a piece of paper. It's really a promise to survivors. So I'm going to stop there. Basically, the state proposals have come in. There's a next PrepCom coming up. Stay tuned for more blogging and more webinars on that. And I'd just like to thank you and Citizens for Global Solution. It's such an honor. And on behalf of victims of crimes against humanity, past, present, and future, it's an honor to be here, and it's an honor to share this, to receive this honor and share this PowerPoint with you. So thank you so much.
All right. Thank you. Thank you so much, Professor Sadat, for those thoughtful and inspiring remarks. At this point, we will now transition into the Q&A portion of our program. I'll begin with questions from our virtual audience, and afterwards, James or Kashay could take over the questions from people joining us from the CGS office. With the current administration's sanctions against the ICC, what is the U.S. administration's stance on this treaty, and how do we move forward for this treaty to support it at the legal public, the general public? Yes.
So what a great question. So all we can know is that the U.S. delegation during the January PrepCom was completely silent. They did not speak. They did not vote. They did not they watched. They had a delegation in the room, but they did not participate. I suspect that the Trump administration won't favor this particular treaty project because it was not favorable to the draft when it was being developed during the years of the Trump one, right? The first Trump administration. But thus far, we've seen pretty much silence. That said, we've seen the administration be very strong in other UN fora, very, very conservative on gender issues. So we certainly, I think, can expect some pushback on at least some of the proposals. But it's very hard for states to say that they're against a treaty on crimes against humanity because it almost makes them sound like they're for the commission of crimes against humanity. So even the most recalcitrant states like Russia and Federation, China, Iran, India, they don't voice their objections as opposition to criminalizing crimes against humanity. It's more procedural obstacles, technical amendments. So we'll see what happens with the Trump administration. And we could talk about the ICC sanctions all morning. I brought one of the first lawsuits in 2020 against the Trump administration for the first set of sanctions. So I'm very familiar with them.
Thank you. Thank you so much. For our second question, we have, could you please explain the movie you made about this treaty and how do we watch it?
Oh, that's so great. So the movie is called Never Again, Forging a Convention for Crimes Against Humanity. There's a little 4-minute sizzle reel, and then the movie's about 40 minutes, and it comes with an instructional like a discussion guide, so it can be shown even to high school students. I've done that in my local high schools. It is on the Harris Institute website. So if you just type in the words Crimes Against Humanity Initiative, you will land on the website and you will see Watch the Film right there. It's freely available. And I also have DVDs. So if you write to me and you want a DVD, because you still have a DVD player, I do, then I can send it to you. Yeah. But it's available to the public. It's also on my website.
Right. Thank you. Thank you so much. For our third question, this is really interesting. You mentioned that the draft treaty includes an opt-out possibility on jurisdiction of the International Court of Justice for
Yeah.
disputes arising around the treaty under the treaty. Isn't this an opt out problem?
Yeah. So, we've actually already seen amendments to that provision from several states that'll be public later this year, but we've actually seen them. There are states proposing to take out the opt-out, and our proposal from the International Law Association study group that I did for the American branch, we propose taking it out as well. The tricky thing, so here's the thing: the question that's open because it's not in the draft is whether the draft treaty will permit reservations or not. And for those of you who aren't legal specialists, right? If the treaty's silent, the assumption is reservations, that is, states can try to opt out of some of the provisions of the treaty, unless they are inconsistent with the object and purpose of the treaty, if that makes sense. That's under the case law of the International Court of Justice and the Vienna Convention on the Law of Treaties. So right now, the draft articles are silent. There's no provision on reservations. Some states would like a clause that said reservations are prohibited, period. No reservations. The strongest enforcement would be no reservations and no opt-out. The counter to that, some will argue, is, well, then states won't ratify the treaty. But that's actually not so clear because many treaties prohibit reservations. The International Criminal Court statute prohibits reservations. The Paris Climate Agreement prohibits reservations. It's not as uncommon to prohibit reservations as one thinks. The US doesn't like clauses like that, but the idea that the United States would ratify this treaty anytime soon is pretty fanciful. It's not going to be first in line to ratify the treaty. It took us 40 years to ratify the Genocide Convention. So I don't think we can think of US practice as really something that should drive the architecture of the treaty. The Mutual Legal Assistance Treaty that was negotiated a few years ago permits reservations to a couple of clauses. So this is a question really of treaty design. Does that make sense? Like there's a relationship between the ICJ jurisdiction and the question of reservations. The strongest treaty architecture, of course, is no opting out, no reservations. And it'll be interesting. And from my perspective, civil society should probably take that position because you want to ask for what you actually want. Otherwise, you're just negotiating against yourself because states are going to come in and they're going to ask for all kinds of things. So I think this is going to be one of the interesting things to watch. I have seen some state proposals have come in saying no reservations, and some state proposals have come in saying no opt-out. And so we'll just have to see where the negotiations go, Margot. I mean, we don't know, right? Um, but our draft had no reservations and no opt-out.
Thank you. Thank you so much.
Yeah.
So we have another question. What is Martin's clause and why is it important to have a good one in the preamble?
Oh, thank you for asking me that question. This is my personal hobby horse. Um, So the Martens Clause is named for the Russian jurist Fyodor Martens, who, when the Hague Conventions were being elaborated in 1899 and 1907, recognized that the danger of treaty codification is you leave some stuff out. Right? Not everything's going to go in the treaty because there are going to be negotiations and and states and groups, because groups can commit, non-state actors can commit crimes against humanity, they're going to think of new awful ways to commit atrocities. So the treaty codification process will never be perfect. We'll never cover everything. Some things will be left out and new things will develop. And so the Martens Clause says, in cases not covered by the treaty, the inhabitants remain under the protection of the laws of humanity and the dictates of the public conscience. And it's a reference back to natural law. It's a reference back to the fact that there are core principles that underpin the entire international legal system, and that those use Kogan's norms, that those core principles, that those basic precepts of humanity are always there even if they're not directly codified in the treaty. So the treaty does have a savings clause provision. It says, nothing in the treaty prevents new crimes from being created under customary international law. But there is always this tricky relationship. Whenever you codify, you leave some things out. And that's where we are seeing the global South, Margot, saying, stop leaving us out. We care about slave trade. We care about colonial crimes. We care about environmental destruction, right? Those are all left out of the 1998 Rome Statute codification. And so one of the goals of the new International Law Association Committee that I'll be directing with my colleague Olympia Beku is to take a look at some of that and say, let's have a 21st century treaty that's really for all humanity. And the Martens Clause is there as a safeguard. And it's how at Nuremberg they were able to adjudicate crimes against humanity was under the Martens Clause. Yes, and thank you. I see Alan Ware has pointed out that the International Court of Justice has underscored the core importance of the Martens Clause. But I'm having trouble getting states to introduce it because it does mean that the treaty will have a certain degree of flexibility. You're recognizing flexibility. And so there's always this tension between states saying, you got to write it all down. And like, we got to know what it is. And humanity saying, well, but wait a minute, 25 years from now, we still want this treaty to be relevant and viable, right? So that's the tension here. Thank you for the question.
Thank you so much. Thank you so much. We have some comments over here, just two comments before we move into the CGS office for any questions. The first comment is from Bill Pace, who says, I was pleased Leila distinguished between the ICC jurisdiction over individuals versus government responsibility. And the second comment is from our board member, Dave Arden, who says, thank you to Ron Glossop for arranging for Leila Sadat to join the CGS National Advisory Council. So thank you so much.
Very
Now,
honored. Yeah, thank you so much, Margot. And thank you. Yes, Ron Glossop, wonderful, amazing human being.
Yes. Now we will go over, we will transition into the CGS office.
First of all, thank you, Leila. Everybody's been applauding you. We're very pleased to have you here.
Thank you.
So Donna Park asks, has there been any support from the Vatican or other religious groups for the treaty?
Yes. So we have excellent support from the Holy See. We have excellent support from Arab and Islamic states. That was kind of a grouping in the Rome Conference. And Israel has been very active in the negotiation. I think of that as sort of those are the core Abrahamic faiths, right? Where we've had some controversy about religious organizations or the Vatican or others supporting the treaty is they tend to be very conservative on gender issues. And so the gender backlash is real. We saw that in the Committee on the Status of Women in March. I came to New York. I'm always in New York. I came to New York for a week and I did 3 events. And many of you who might have followed CSW know that the United States was particularly problematic in forcing a vote on the resolution. And so the treatment of women and girls in particular is a huge issue that we're going to have to fight very hard for. So we welcome, of course, everybody welcomes the support of faith-based organizations. At the same time, imposing what I would say regressive definitions of gender, anti-homosexuality campaigns, anti-abortion campaigns, family first campaigns. Those I don't really welcome. I'm speaking for myself personally, and we have a coalition that's forming for the treaty and to support the treaty campaign. And we want the treaty to be gender competent, and we want gender parity and gender expertise in all delegations. Because look, women, peace, and security, the treatment of women and girls is critically important to the rule of law. And so where you have countries that are actively discriminating against women and girls, where there is active negativity on gender issues, you're going to have more human rights violations and you're going to have more conflict. And the Taliban in Afghanistan is one of the most extreme examples, but there are other examples as well. So we welcome, of course, all faith-based organizations, theocracies, the Holy See. They've been very supportive of the treaty campaign, but not necessarily supportive of some of the goals of most civil society, which are to promote a treaty that includes all humanity and doesn't enshrine sort of 19th century or early 20th century conceptions of gender and sexual orientation.
Gail Hughes here in the room asks, at present, the ICC seems to be used in some ways to benefit or to target certain groups and not others, or they have been more prosecuted. And what's to ensure that this won't be the case in the future, that it will be used in an egalitarian way or a fair way?
Yeah, so that's a two-part question. So there's an assumption about the ICC there that I might challenge, to be honest. I think the International Criminal Court, if you look at the activities, I'm no longer with the office, so I'm speaking entirely in my personal capacity. I think if you look at the situations under investigation and the arrest warrants that we know are publicly available, because there are lots of arrest warrants under seal, I think you will see that the ICC has now moved into many situations that involve the wealthy and the powerful. As opposed to other situations. That said, it's always going to be harder for the court to obtain the presence of the accused in situations where crimes are being committed by individuals in wealthy or powerful states that can evade arrest. And that was true in the Yugoslavia Tribunal. We thought the ICTY would fail because it couldn't get Milosevic, it couldn't get Mladic, it couldn't get Karadzic, and eventually they got all of them. The fact that former Filipino President Rodrigo Duterte is in the dock at the ICC, I think is a huge positive. So I think patience and persistence is also a hallmark of the ICC. And remember, states are underfunding this court tremendously. And it has other problems, right? The scandal involving the Office of the Prosecutor is clearly a self-inflicted wound. But I think the idea that the ICC is targeting some groups and not others, I think I would actually take issue with that. Now, when we move to the treaty, remember the treaty is not about creating an international court. It's about empowering states to do the job themselves. And so states are supposed to prevent crimes against humanity, and states are supposed to punish them or extradite to states that could punish, right? Belgium versus Senegal in the Torture Convention. So a great example is former Syrian president Assad was indicted in France under universal jurisdiction. And you would, with a new treaty on crimes against humanity, not only have the possibility to indict on crimes against humanity, but to have a whole set of interstate cooperation provisions, et cetera, that could be used. So now, can universal jurisdiction be abused? Can states use their criminal jurisdiction in a way that's abusive or politically motivated? Of course they can. So the treaty has to contain safeguards. The treaty has to have safeguards on the human rights of the accused, and there are fair trial guarantees in the draft articles. States are now arguing that they need notice, right? They want notification requirements that if a state is investigating foreign officials, that in fact they'll be notified of that. And the International Law Commission draft that was just adopted in Geneva on immunity of state officials from foreign criminal jurisdiction is going to be very relevant, I think, to the discussions in New York on crimes against humanity. And I'm going to Geneva in July. Yes, to do more treaty work, but to really see what is the International Law Commission thinking, because I know we're going to hear echoes of that in New York when it comes to the treaty negotiation. So, it's not just the US sanctioning the ICC, right? The Russian Federation has actually tried ICC judges and the prosecutor in absentia. And so, states can abuse their criminal jurisdiction. That's absolutely true. And so we do have to have safeguards against abuse, but we also have to have a strong treaty that doesn't allow individuals to escape or have impunity for the commission of international crimes. And that's going to be a really interesting balance to achieve.
Thank you, Leila. We're coming up on time, and we know you're very busy and have a lot of important work to do, but we have one important question from the room, which remains, which is, how can CGS best support your work moving forward?
Oh, I think there is going to be a coalition where we have a steering committee and we're creating a vehicle for individuals to join the coalition, mostly so we can our goal is to have a listserv and to have sort of quarterly meetings where all entities that join. So I think join the coalition as it's forming, and you can email me and I'll email the information. Individuals can also join. It doesn't have to be an organizational membership. I think information is also critical. Education, what you do with CGS through your conferences and your newsletter and your webinars. I think we need to do a lot of work here in the United States, obviously. Why international law matters, how is international law made? I have all those pictures of my students because most of them had never been to New York. Here you have the United Nations is on US soil. It's in New York City. They'd all been to New York City. They just never went to the UN. And I went to the UN on a fourth grade field trip, and I swear it changed my whole life. Like, I didn't think of it as a career at that point or that I would be an international lawyer, but just being in that kind of magical space, watching the General Assembly, looking at all the artwork donated, the Chagall Peace Window. It's a very beautiful space, right? And so I think educating Americans, when I take my law students now, we get them accredited. So they get their little badge. They're super excited about their badge. They get a credential. They get to go in the building. They get to meet delegates. They are so fired up and so excited. And so I think getting our young people and maybe getting some of our senators and congressmen to actually, instead of, throwing rocks at the UN as sort of this organization that, is bad, just bus them there, take them there on a field trip, have them meet with delegates, have them see, because what I found as an educator is when I took my students to the International Court of Justice in The Hague, when I took them to the ICC, when I take them to the UN, and they see how really smart, well-intentioned people are trying to make international law work in an imperfect world, that really changes the way they look at things. So I think our job is education, 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 to try to get our country and our leaders turned around. Yeah. Yeah. I hope that's helpful.
Thank you, Leila. We wish you a wonderful day and continue to support your work moving forwards. We will do everything that we can. I will hand back over to Margot to close us out.
Thank you so much. It's really an honor to be with you. Thank you so much. We'll get this done together.
Again, thank you so much for everyone that has joined us today. Thank you, Leila, for being here. And again, congratulations on your award. Well deserved. So at this time, we appreciate everybody's participation and thoughtful engagement. Thank you and have a nice day.